ready? Start. This revision is directed against the judgment and order dated 2/11/2019 passed by special judge within bracket POSCO Act bracket close additional sessions judge court number 9 Mathura dismissing juvenile criminal appeal number 68 of 2019 within bracket Syamu versus State of UP and another bracket close filed under section 101 of the Juvenile Justice within bracket Care and Protection of Children bracket close Act 2015 within bracket foreshort the Act bracket close and affirming an order of Juvenile Justice Board Mathura dated 7/8/2019 refusing the bail plea to the revisionist in case crime number 489 of 2018 under sections 498A, 304B, 323 IPC and section 3/4 Dowry Prohibition Act, Police Station, Barsana District, Mathura. Stop para. Heard Sri Manish Tiwari, learned senior advocate assisted by Sri Atharv Dikshit, learned counsel for the revisionist, learned AGA appearing for the state and perused the record. Stop para. The prosecution case, as per the version of the FIR, is that the marriage of the deceased of the present case, namely Srimati Neetu, who happens to be the daughter of the first informant of the present case, namely Ramesh Chandra, was solemnized with the brother of the revisionist, namely Satyapal, on 25/4/2015, and allegedly after the marriage, the husband of the deceased, namely Satyapal, mother-in-law of the deceased, namely Vimla Devi, father-in-law of the deceased, namely Vijendra, and the revisionist used to torture the revisionist in lieu of demand of dowry. Stop para. It has been further alleged that on 12/10/2018, the husband of the deceased, namely Satyapal, informed the first informant over the phone that in a cylinder blast, the deceased of the present case, Srimati Neetu, has sustained injuries and she has been admitted in hospital, and upon receiving the said information, the informant reached the hospital where he was informed by the deceased that it was the co-accused Vimla Devi who had set her ablaze by pouring kerosene oil on her with the help of other persons. Stop. The FIR initially lodged on 13/10/2018 under sections 498A, 323, 326 IPC and section 3/4 Dowry Prohibition Act, which after the death of the deceased was converted to section 498A, 304B, 323 IPC and section 3/4 Dowry Prohibition Act on 25/10/2018. Stop. Learned counsel for the revisionist further submits that the revisionist is innocent and has been falsely implicated in the present case. Stop. The revisionist has no concern with the demand of dowry and he is not beneficiary of the same. Stop. No specific role has been assigned to revisionist regarding demand of dowry or treating the deceased with cruelty for non-fulfillment of demand of dowry. Stop. It is further submitted that the entire allegations leveled by the prosecution are entirely false and preposterous and hold no iota of truth in them. Stop. In the FIR, merely vague and omnibus allegations regarding demand of dowry have been made by the first informant, and it has not at all been mentioned as to what was the demand being made by the accused persons from the deceased. Stop.